Snyder.
Good morning. Please the court, counsel. My name is Dave Snyder. I'm here to represent the appellant, Dennis Ribaya. With the court's indulgence, I'd like to reserve 10 minutes for rebuttal.
Nope, you can reserve 5, but you can't reserve 10.
All right, Your Honor. I'd like to reserve
Can't reserve
5.
half your time.
All right, thank you, Your Honor. Mr. Ribaya is here in the courtroom today, and he's a retired Tampa firefighter, a member of the pension fund, beneficiary of the pension fund, which is administered by the defendant board in this case. Mr. Ribaya has always been very attentive to pension matters. He makes document requests. He attends pension board meetings. He attended the June 2012 meeting of the pension board. He spoke to the board. He was thanked for his remarks to the board. There were no incidents at the June 2012 meeting. Nothing was said to Mr. Ribaya about having done anything wrong or said anything wrong, either during or after the meeting. No admonitions, no warnings. So Mr. Ribaya was surprised in July 2012 when he showed up to attend the meeting, and he was met by Tampa Police Department officers who delivered to him a 90-day trespass warning that had been requested by the chairman of the pension board. Mr. Ribaya read the TPD papers which were presented to him, preventing him from attending on pain of arrest, and discovered in those papers that the board was falsely accusing him of having said a foul word during the June meeting and falsely claiming that he had disrupted the meeting. The minutes of the June 2012 meeting, which were adopted after Mr. Ribaya was trespassed, make no mention of any disruption whatsoever. But perhaps more importantly, the board's own recording of the meeting, which is we obtained pursuant to a public records request, reveals and conclusively proves that there was not any disruption whatsoever of the June 2012 meeting.
As a practical matter, given the procedural posture of this case, that's what you pled, so we assume the truth of that for purposes of this appeal, don't we?
Yes, Your Honor. Even though Mr. Ribaya didn't have to, he asked the board to let him be heard on the remainder of his suspension. He was kept out of the July 2012 meeting, so that horse was out of the barn, so to speak. But he asked to be heard on the continuation of his trespass, and the board refused to grant him a hearing on that.
Let me ask you this, Mr. Snyder.
Yes, sir.
The documents that Mr. Ribaya received with the trespass warning reflected an accusation that he had used a foul word. Did it specify the foul word, or did it just say used a foul word?
My recollection, Your Honor, is that it just said he used a foul word. And then I didn't have to, but I contacted the board by letter, and I also contacted interim board counsel, not counsel representing him today, but previous counsel, and spoke to him on the phone. And I discovered that the board's position was that they had done nothing wrong. There would be no cure of what occurred, the Sunshine Law violation in July 2012, and there would be no opportunity for Mr. Ribaya to return to the remainder of the public meetings during his trespass warning. And we discussed such ideas as having the meeting someplace else so he could attend, but that was fell by the wayside.
Are these, that was sort of confusing to me in this. Are these meetings video cast or something, so you can see them outside the room?
No, Your Honor. They are recorded. The board itself makes a recording, at least at the time, made a recording of the meeting. And when the chairman of the board was talking to the board about why he trespassed Mr. Ribaya, he said that that this foul word was on that recording. And so when I made my public records request, I asked for the recording that he referred to in the meeting. So I'm confident.
And I'm not sure this is in the record, but I'm sort of curious as how many members of the public attend this this kind of a public meeting? Are we talking about 30 people come to these meetings, or are there 300, or is there any?
I think I had this
Just Mr.
discussion with my
Ribaya.
client. I'm sorry, Your Honor.
Or just Mr. Ribaya?
No, Your Honor. Well, Mr. Ribaya, I know Mr. Parker, who I believe is also here today, whom this court knows from his own case, maybe not this panel, but this court. I know Mr. Parker was there. Mr. Urbichai, who was also here today, was there. My understanding is that roughly a dozen pensioners or other interested parties attend, but that could be more. So Mr. Ribaya is not the only one who attends.
And these are held where?
I beg your pardon? Your Honor?
Where is the meeting space?
They're held in the pension board offices, which is their own public space, and I believe it's on North Boulevard.
They have their own building or?
Yes, Your Honor. Yes, Your Honor. And they have a conference room in that building, and that's where the meetings are held. So we were in court, in circuit court, before the trespass warning had expired. I think that we filed in September 5th, and the September meeting was later in the month, and he was banned from that as well. And we asked for a judgment, number one, that Mr. Ribaya's banishment without cause violated Florida Constitution and the Open Meetings Law, which I'll refer to as the Sunshine Law.
Because your position isn't that they can't keep someone from attending if they're misbehaving in some fashion. It's that this particular rule and how it was applied to your client was wrong. Is that?
Yes, Your Honor. Whether the board can ban somebody who disrupts the meeting is not at issue in this case in any respect at all, because Mr. Ribaya didn't disrupt the meeting.
But you think you're entitled to a declaratory relief as a determination as to whether or not factually he was properly banned from a meeting?
Yes, Your Honor. I think we're entitled to a factual finding by the lower court that, number one, he did not disrupt the meeting, and then based on that factual finding, that was a violation. It was a violation of the Sunshine Law to exclude him. And the further relief that was requested is that pursuant to Section 286.011, subsection 1 and 4, any action that was taken while the board was in violation of the Sunshine Law is void. And I'm thinking, probably the court could do this in steps. It could make a finding of violation of the Sunshine Law first, and then see if the board wants to cure it. If they want to cure it, then the court can go back and then order it be void, and then that would force the board to cure it.
So you would let us off the hook about whether we would declare void, just absolutely declare void anything that happened in the interim?
Well, at this point, Your Honor, I don't think you're on the hook for that, because you need only reverse and remand and say this states a cause of action, and we need a decision on the merits.
Okay.
Yes, Your Honor. Although we certainly would object if you wanted to go that extra step.
To some degree, this case, though, seems to go beyond the individual circumstances of your client, and maybe goes to what are the parameters of a public body's ability to declare what a disturbance is for purposes of removing them without violating the Sunshine Law. I mean, it seems to me that what your allegation is, and I don't know whether this is in your complaint or what, but I gather best case scenario perhaps for the board is he turns to someone and says, "Oh shit," or some along that during a break, and that this turned up on the tape of the meeting. And sort of retroactively, the board declares that to be disruptive, even though no interruption of the proceedings or whatever happened at the time. That would seem to go beyond the question of your client's individual circumstances, but how could anybody declare sort of ex post facto that what it found offensive was in fact a disruption? Is that fair?
I think that's a fair reading. It goes far beyond what is necessary to reverse this case, of course, because initially the break in the meeting was not recorded.
Okay, so the "oh shit" would not even have appeared on the tape.
Yes, actually, what Mr. Ribaya, Mr. Parker was sitting next to him, And he said, well, do you think they're going to answer your public records request right away? And Mr. Ribaya responded, shit, no.
Okay, shit, no,
And
sorry.
So, but we eventually resolved the public records request, but none of that occurred during the meeting. And and as a result, none of that was captured on the tape of the meeting.
And of course, ask a couple other things.
Yes, Your Honor.
If I have it right from your second amended complaint, at least the allegation is that he was not notified that he was going to be trespassed until he arrived at the meeting a month later?
Yes, sir, he had no idea.
Okay. And coupled with that, other than a judicial proceeding, is there some administrative mechanism by which he can challenge the board's decision to keep him from attending one or more of these meetings?
We are told by the board that its procedures, and Mr. Ribaya was told by the board that its procedures did not allow him a hearing. However, the 11th Circuit authority, and it's not really involved in this appeal at all, but there's 11th Circuit authority says you can't trespass somebody from public property without affording them due process. And maybe way down the road that might be an issue in this case, but it's not an issue today.
Okay. Tell me, and I apologize, I was going to read all your case law yesterday, and my father had a medical condition that caused me not to read the cases yesterday. I will read them, but on the notion that keeping one person out of attending a public meeting voids all action there, that this sort of what I'll call the ultimate per se error. What's your best case that is similar to this? Because it strikes me that, you know, a school board that may have 400 people that attend month in and month out, and they expel one person, it seems like the penalty might be extreme for the nature of the violation to me, and I'm wondering how that plays out.
I'd be very happy to address that, Your Honor. First, the primary authority for the acts taken outside the sunshine being void is the Supreme Court's Gradison case. And in that case, there was a violation of the Sunshine Law, and the Supreme Court said that a Sunshine Law violation in the past is an irreparable public injury, which requires that the materials, and in this case, it was the adoption of an ordinance in the Gradison case. So the ordinance adoption was void, okay? And then in the Toller case, which was a later Florida Supreme Court case, the Toller case outlined the procedures for fixing that. In other words, the board all it needs to do is put the ordinance back on the agenda, go back and do what they should have done in the sunshine, and adopt it again. And while it's, you know, certainly I'm sure hurts their pride to be told that they didn't do it right the first time, it's a very simple procedure.
I know there are minutes in the record someplace, but I haven't actually analyzed what activity took place. If we were here to hold that it had voided all action at these 3 meetings, what was it that they decided, and what would the sort of the practical impact of that sanction be?
Well, there's a laundry list, Your Honor, and it would take the rest of the morning probably, because we had 3 months of activity.
There are lists of people who are allowed to go into drop or into the pension system and things like that.
Yes, Your Honor, and the board has argued that there were pension benefits that were authorized during those meetings, and
if we were to hold those actions were void, would that mean that there are a bunch of people who wouldn't be in the pension for the last year, or
well, no, Your Honor. I don't believe that would be true, and that's why I suggested at the very beginning, you know, Judge Crenshaw's opinion in the Angelo's aggregate materials talks about the terrific utility toolkit that the declaratory judgment statute creates. So the trial court would have a huge toolkit to deal with this situation, and that's why I suggested probably the best way that I would recommend to the trial court to deal with it would be to find the Sunshine Law violation and then give the board an opportunity to accept that and cure it in maybe a partial summary judgment or something like that. And then if the board didn't want to do it, then I guess it has to own its decision in doing that. And that's there's a Silver Express case where the very same argument was raised. That's a 3rd DCA case cited in my brief. And the court says, you know, the board is very upset about having to go back and redo this. They think it's an onerous remedy. But, you know, the board can cure this. There's a procedure set out in the case law to do that. And the board owns its own decision not to do that earlier. And we're going to go ahead and find that it's void. So I don't think we'd ever have to get to that in this case. So I think it's important to say that these cases which determine that a past action is void are not determinant on whether that action can reoccur or not. The case is not moot because it might not reoccur, and I would hope, and I've said this to the trial court, you know, the board has different counsel now. Their counsel is very professional but also very knowledgeable in this area, so I can't see this happening again. And in fact, they officially admitted that the original policy was bad because they amended it, so it's not going to happen again. And so that, in terms of whether it's void or not, is not an issue.
I tell you you're beyond your 15 minutes that you didn't need 5 minutes of. So
Well, Your Honor, I will sit down and reserve a few minutes if I may. And I thank the court for the questions because you actually helped me cover some of my argument that I was going to make and beyond.
Thank you, Mr. Snyder.
Good morning. Stuart Kaufman on behalf of the Board of Trustees. And I thank Mr. Snyder for his words this morning about our firm and being professional and knowledgeable, and I hope you find the same this morning.
Mr. Kaufman, just for clarification, what firm are you with?
Klausner, Kaufman, Jensen, Levinson out of Plantation,
Great.
Florida.
Okay.
Yeah. We serve as general counsel for the board as well, and we came on as counsel probably about 2 years ago, right after all this occurred. And one of the first things that we did was to amend the policy, not because we thought that there was a problem that was violative of the Sunshine Law, but maybe because there was a problem that there might be constitutional problems with it, simply because the law has been changed since then. And 286.0114 was passed, which provides that now there has to be a public comment portion during the meeting. So public is welcome and to attend, and they're also welcome to provide comment. So if we were to trespass somebody, now, the way the law stands, as it was changed last year in 2013, there could be an argument that it might be a prior restraint of speech to trespass somebody for 90 days. But at the time, I do not think that there was this constitutional infirmity.
Well, now, would you agree, though, that if the question of whether there was a Sunshine Law violation was not rendered moot by the fact that the trespass period had expired?
I think that, and because I don't think it was capable of repetition, because we changed the policy.
Well, no, but I mean, the question isn't just whether he is now permitted to return, is it? The determination of whether this violated the Sunshine Law wasn't resolved by his return.
I don't think he would be entitled to a declaratory judgment, but maybe some relief under the Sunshine Law. There were 2 counts he brought. He brought 1 count under the Declaratory Judgment Act, and the 2nd count was under the Sunshine Law. But because we amended the policy to provide that even if you are trespassed, you can still attend a meeting, I think it is moot on that point. Because it's not capable of repetition. And as long as we're counsel, we're not going to let that happen.
Right now, there's public record documents and a police citation saying that he engaged in activity that could affect his reputation, and the board provided no mechanism for him to challenge that at the time. So why isn't just that enough to allow him to
I guess we're saying that that's not really an attack on the Sunshine Law. It's an attack on the trespass warning. And there were means, maybe not administratively, and it is in the record, and it was attached to the complaint that he sought a hearing, and he was provided with some correspondence back saying that he was not entitled to a hearing under Policy 108. But he could have challenged it in court. He could have challenged it, maybe a First Amendment claim, maybe a civil rights claim, 42 U.S.C. 1983 claim, but not on the Sunshine Law claim. It's not violative of the Sunshine Law to trespass somebody and have that one person not be able to attend the meeting.
So
go ahead, I'm sorry.
So we make our case simple. It's undisputed that they arbitrarily and capriciously kicked someone out of a public meeting who wanted to be there, not necessarily to speak, but because the issue was important to them. is that or is that not a violation of the Sunshine Law?
In our reading of the law, it's not a violation of the Sunshine Law. It might be a violation of the trespass warning, and that's why you attack the trespass itself, and that's what the trial judge found in that
What in
below
the
also.
Sunshine Law causes you to reach that conclusion?
Well, the case law, there's no case law out there where a trespass was used to find that there was a violation of the Sunshine Law. Has
there been a case that said it was a violation of Sunshine to keep one or more members of the public out of a properly noticed meeting?
There's one case, the Ribaya case, where the board held a meeting that was over 100 miles away from the county, from Alachua County, and one individual brought a claim saying that that violated their Sunshine Law claims. But the court in that case said that the public at large, being the whole constituency of Alachua County, was excluded from the Sunshine Law.
Okay.
Merely to hold, the meeting was open to the public, anybody was welcome to attend, but for the fact that he was issued the trespass, Mr. Ribaya was not allowed to attend. And that's why I think it just applies to this one individual. Otherwise, the court below found that it was open to the public as a whole. There was a reasonable opportunity for the entire public to attend the meeting.
I'm going to comment briefly on sort of the standard of review in this, because the case law on this is sort of messy. My take on it, at least, and I think from this court's take on it, is that whether the pleading states a cause of action is a pure question of law, and then whether or not, if it states a cause of action, it's one that merits judicial time to go through the process of providing declaratory relief, that a judge can use his or her discretion not to go forward with a case that states a cause of action because, for whatever reason, it's just one that doesn't necessitate that action. And your motion, by the way, to dismiss didn't really say it didn't state a cause of action. It's a speaking motion that goes on along the way. So I wasn't too sure. And the judge seems to be making a mixed ruling as to whether it's too much trouble to do this hearing, or because it's moot, or that it doesn't state a cause of action.
I think that there was, well, we didn't specifically say that it was failure to state a cause of action, but I think that it was failure to state a cause of action on declaratory relief action.
The position is that as a matter of law, the exclusion of one person, albeit even if improper, does not constitute a violation of the Sunshine Law.
That's exactly what we're saying in the case.
Okay.
And to void things, I mean, what we're talking about voiding would be payments. They ratify the payments to the beneficiaries. There are over 1,800 retirees that get a monthly check every month, and he's asking you, well, he's just saying void everything, but he's not complaining of one thing that occurred at any of those meetings. He's not saying you did this and I didn't agree with it, or and actually he gets a benefit payment every month. So if he's saying void what we did, he's saying that part of the relief that you're going to be granting is to void a benefit payment that I received for this during this 3-month period. It's impossible. And if you look at the Leach Wells case, which was a second DCA case in 2009, Judge Northcutt was on the panel. You said that even if there was a Sunshine Law violation, and you said that there was a Sunshine Law violation in that case, if the relief is impossible, then you do not grant the relief being sought. We're saying, in that case, construction had already started on a building, and the building was built already, and you said that it would be impossible to grant the relief therein. We're saying it would be impossible to go back and void these over 5,000 payments to the beneficiaries and retirees.
Well, I don't know. I think what you're arguing is that it would be untenable, not impossible.
It would serve absolutely no useful purpose. Just the amicus brief in this matter had brought up an issue of the constitutionality of the policy. I'd just like to state for the record that it's our position that that is not before the court at this present time, as it was not raised by Mr. Snyder in the amended complaint.
Okay.
Thank you. If you have no further questions, I rest.
Thank you, Mr. Kaufman.
So, Mr. Snyder, we've maybe narrowed this down to, is the improper kicking out of your client a social faux pas, a violation of civil rights, or is it actually a Sunshine Law violation?
Well, Your Honor, it is a sunshine law violation, and the court doesn't have to address today whether it is or is not a violation of some other constitutional right, the right of due process, the right of freedom of speech, which, by the way, at the time, Mr.
And is that 100-mile case the only one that has dealt with the exclusion of a person or a small group of people from a
Thank you
public
for
meeting?
asking me that, Your Honor. No, Your Honor. There's an Attorney General opinion cited in my brief in which the Attorney General was asked if, by I think it was a school board, said if we're talking about a particular employee's performance as an employee, can we keep them out of a meeting because it's awkward, And the Attorney General says, no, you can't do that. That would violate the Sunshine Law to keep one employee out. And the court
Is a distinction, though, when it's one employee that is the subject of the meeting as to someone who merely wants to observe a broader topic?
No, Your Honor, there's no distinction there whatsoever.
It would be far different if the topic at the July meeting was whether Dennis Ribaya got a pension or not. His exclusion from that would seem to be a different issue.
No, Your Honor. No, Your Honor. I mean, if I were here on behalf of my newspaper clients saying they kept my reporter out, the court wouldn't be saying, well, the reporter's interest is just the interest of the general public because they're a representative of the public. And I don't think that question would even come up, and it shouldn't come up in this case. Because Mr. Ribaya, whether he has something at stake in the meeting or whether he doesn't really care about the meeting, he's just getting out of the cold. He has a right to be there.
The sunshine applies to all ordinary citizens without regard.
It applies to everyone. And it applies to not just the citizens of the state, it applies to the public, which goes to any person.
Right.
Your Honor, on its face. And another case, for example, about keeping just a few people out is the Port Everglades case, which is also cited in my brief. In that case, they said, well, let's keep these bidders out because we're entertaining other bids. And in that case, who challenged it? It was the labor union who was interested in the proceedings and about who got the contract. So it wasn't even the person who had an interest in, or they had a reason to exclude who challenged it, but they had a successful challenge on behalf of the labor union. And one of the cases I cited doesn't come to mind immediately, says that what the Sunshine Law does is afford anyone the remedy to act in the place of the public and challenge a violation of the Sunshine Law for any violation. And of course we have to go back to it that there was, as Your Honor said, Mr. Rabaya's exclusion under the complaint was arbitrary and capricious. Absolutely no reason for him doing it. And just briefly, in the Leach-Wells case, which was decided by this court. Well, what happened in the Leach-Wells case was that somebody claimed a Sunshine Law violation and went in for a preliminary injunction, saying it was someplace along the string of meetings that led to authorization of a project. There was a Sunshine Law violation. Therefore, this project should be enjoined because the adoption of approval of the project, was tainted by a Sunshine Law violation. The court denied the preliminary injunction, and the plaintiff didn't appeal. By the time the permanent injunction was considered, the project was built. And the court obviously couldn't, while it said, well, yeah, there might have been a Sunshine Law violation in the past, we obviously are not going to go in and order this private developer to tear down this project because even though there was a Sunshine Law violation, it's impossible to cure it now. This case is vastly different. As I said before, all the board has to do is, sort of buck up and say, yeah, or the court will tell them to buck up and say, yeah, you violated the Sunshine Law, now go back and cure it. All done?
Thank you. Thank you.